debating these issues, there are options that will continue to be considered. And obviously, we have an elected leadership. It will continue to give guidance on the options that we shall pursue as members.
I'm asking about the consequences. If we don't elect these ones, what will happen? Like election?
I think the challenge that we will have, if we do not have an election, it will mean that we shall have, under Article 146 of the Constitution, the Judicial Service Commission must be composed of various representatives of various organs, including Uganda Law Society. Therefore, if we do not have this election and the term of office expires, which it's doing this month, of the two members currently representing Uganda Law Society, we are going to be in a constitutional vacuum. In which case, it will be unlawful for Judicial Service Commission to continue operating, processing appointments of judges and magistrates when it is not lawfully constituted. We are right now facing attacks and criticisms from some of our members who claim that our leadership is not lawfully constituted. But some of them are the same people who don't want us to ensure we have a lawfully constituted Judicial Service Commission. The Judicial Service Commission must be lawfully constituted as per Article 146 of the Constitution. And if that does not happen, it's going to be our view that all the appointments that will be made, all the actions made by the Judicial Service Commission in that state will be unconstitutional.
Thank you so much, members, for your questions.
Legitimate and lawful activities. We are not exaggerating. It's what it is.
Maybe, Council, a question, simple one, question of clarification for me. You see, you have members of the Law Society who are agreed with what is going on, and they went to court where they thought maybe they would seek redress, and at this particular moment, we can say the courts are on their side. How else would you have expected your members who are not happy with the ongoings to have the issues addressed? Because at the end of the day, they will also say they have taken a legal procedure, and the courts at the moment seem to be in agreement with them, though temporarily. So how else would you think would they have had the issues addressed?
First of all, we have got a framework under the law that governs the operations of Uganda Law Society. The Uganda Law Society Act, Chapter 305, Laws of Uganda, provides a right to members to requisition with only 15 signatures to requisition for an extraordinary general meeting. Uganda Law Society right now has a membership that's over 5,000 members. But because we are following a law that was enacted several years ago, in 1956, it requires a member who is aggrieved. Any member who thinks the leadership has gone astray, who thinks the leadership is misbehaving, who thinks the leadership is departing from the mission of Law Society, has a right to requisition for an extraordinary general meeting. And all that such a member needs are 15 signatures of other 15 willing members to cause such a meeting to address those concerns and pass resolutions. And therefore, when a member rushes to go to a court of law, we expect that the court will take into account the provisions of the Uganda Law Society Act. The law requires that before you go to any court of law, you should first exhaust the internal administrative remedies. When that has not been done, and then a court of law issues an order stopping an organization with 5,000 members from carrying out any meetings because one member is aggrieved, it's simply a travesty. It's an affront to democratic rights of members. You can't have one individual stopping 4,999 members from meeting and discussing their affairs. Courts of law are required to apply the law. And what our biggest concern at the moment is that these cases involving Uganda Law Society are not being determined in accordance with the law. And orders are being given, then the courts of law are delaying determination of the substantive disputes, and therefore that renders it impossible for Uganda Law Society to carry on its lawful mandate. The Service Commission has two members whose job is to represent the public interest. And therefore, we are trying to sensitize members of the public to know that it's important to have elections of the Bar Association, to choose our representatives who make input on the appointment of judges and justices. And therefore, the lawful means for challenging this order, which we consider obnoxious and a travesty of justice, will include going to the, may include appellate options, may include administrative measures, as well as sensitizing the public. All that we emphasize, because we are the Uganda Law Society, we operate within the ambit of the law, but the options we have on the table are not only going to be limited to challenging these orders in the courts of law.
You've talked of the lawyers to join you. How do you want them to join you? Do you want to post things on Twitter, WhatsApp, social media, and so on? Do you want them to come here to show that they are with you? What is it?
I think we are, first of all, we thank all the members of the bar who have already been supporting this process. As you can see today, we have here in this room over eight candidates who have sat together in a bipartisan manner to sign off a joint statement. That's the kind of support we need from all the lawyers, because the process which is going on, the legal process, the injunctions which have been granted by the court, are really an attack on the legal profession in Uganda. They are not simply an attack on law society, and maybe it is important to emphasize that this is not the first injunction, it's not the first time. We had an injunction issued by the same court in February this year. For sure, we didn't have the current leadership of the law society, and therefore nobody should be deceived that because of the elected leadership we have, somehow now the judiciary is at loggerheads with the law society. No. The only thing that has changed is that we simply have a leadership that is determined to be assertive and ensure that further erosion of the right and independence of the bar comes to a halt.
If you talk of holding the rule of law and lawyers and people at the bar, one may say that because the case is in court, one may say that you have waited for what will come out from that case. Then you go on with whatever you would like to, because you have to hold the rule of law. What is your take on that?
No, the rule of law involves a number of things. One, it requires that judicial decisions must be delivered in accordance with the law. And our complaint now is that we have decisions guarding Uganda Law Society, they are not delivered in accordance with the law. Some of our individual members are going to the courts of law and getting orders against the Bar Association, which orders clearly are not grounded in the law. And therefore we have to object to them. We will challenge them legally, but we shall also make it clear to the public so that everyone appreciates what's going on, because a guarded law society is very dangerous for the society, for the whole country. Law society does a lot of work. And if it becomes impossible for law society to carry on its legitimate and lawful activities, then it's bad for the public good.
Now that you came as the counsel for